attorney's perspective, we have former assistant public defender and a former city prosecutor of the city of Orlando. She was also a legal advisor to the Orlando Police Department. While city prosecutor for the city of Orlando, she was appointed special assistant state attorney for the 9th Judicial Circuit. She now serves as a private criminal defense attorney and previously served as counsel for George Zimmerman. Ms. Zahra Umansky. Our next highly qualified panel.
Supporters, the stand your ground law is all about the right to self-defense. To critics, it's a license to kill. Which side do you think is closer to the truth?
Well, Mr. Owens, I believe in the stand your ground law. I think that every law can be used by bad people to do bad things, but if it's used by the right people to do the way it's intended to be, then it's a useful law. I don't know how many of you remember the defense of voluntary intoxication that we used to have, which was repealed by the legislature. I believe it's been at least 10 years. Well, the reason why that defense was repealed was because people would go out, get drunk, and they go kill their spouse and say, hey, I was too drunk to know what I was doing. So any law can be used for a bad purpose. Unfortunately now we don't have that defense anymore, which could actually, sometimes somebody can be under the influence of a drug or alcohol to the extent they don't even know what they're doing. They can even form the intent, but now we don't have that available to us. So I believe the stand your ground law is a good law, and I've used it for my clients before. Going back to what Senator Simmons was stating, because it's a creation of statute, it doesn't apply retroactively. So that's something to consider too. So if there's anyone who is accused of a murder that happened pre-2005, or a crime, a capital offense, or maybe they failed to appear, they have to fall back on what the common law was, which in Florida was it's either self-defense, if it happened in a public place, you have to retreat. You need to retreat. So you can't argue stand your ground in any cases that come up pre-2005. They might still be around. And also, as far as how do you argue or put into action stand your ground immunity? And remember, it's not an affirmative defense, it's immunity. So you can bring that forward through a motion to dismiss pre-trial. When you file your motion and have the judge hold an evidentiary hearing, and the defendant has the burden, preponderance, to prove beyond the preponderance of the evidence that they're entitled to the immunity. And for those of you who are not familiar with what does that burden mean? Well, if you think of the scales of justice, whoever tips the scales has proven their case beyond preponderance of evidence. So it's obviously not a burden as high as beyond the exclusion of every reasonable doubt, but they've got to be convincing enough so the judge says, you know what, you're immune from prosecution. We don't even need to let this go to a trial. So the initial burden is with the defense. Now, there's been some argument in the media that in the George Zimmerman case that they may actually even forego the stand your ground and just argue in self-defense at trial. I've seen some speculation about that, whether or not that's going to happen. And that's going to be interesting because what happens if you're not successful at stand your ground, motion to dismiss before the court? What are your options then? Well, now you can argue it to a jury at the trial, but now the burden is a little bit different. It's self-defense, and now you got to do a prima facie case of self-defense as a defendant, and you might say, well, what is that? Because I don't know how familiar everyone is with those terms, but you may want to think of prima facie as sort of like a checklist. It's not preponderance of evidence. Preponderance of evidence, you've got to be convincing. You've got to get the judge on your side. Prima facie it's a checklist. I showed you A, B, and C. You don't have to be convincing. You just have to get it out there, the facts, enough so that the judge will say you're entitled to a self-defense jury instruction for the jury. And now the prosecutor must prove to the beyond that it's not self-defense beyond a reasonable doubt. So your burden is higher in the motion to dismiss as a defendant, where it's a little bit lower when you go to a jury trial. So strategically, is that why the defense in the George Zimmerman case may be waiting for trial if they decide to do that? We don't know. Or it could be, once you file the motion and you have the evidentiary hearing, you're putting everything out there, the state knows your strategy, what your witnesses are going to say, you subject your client maybe to cross-examination, and maybe you don't want to do that. Maybe you feel that you're not going to be, you might as well save it all for trial. And that might be a reason why. And we've talked a lot about guns, but we have to remember, stand your ground can be any weapon, any deadly weapon. I had a case where it was a bat. And in that case, the court found that my client could have used a certain amount of force. However, it wasn't reasonable the amount of force they used. They used the bat, the alleged attacker used their hands. And the court said, you know, a bat versus fist, the amount of force was not reasonable. So could that be an issue in the George Zimmerman case? Maybe, it depends on his injuries and how are they going to present them as life-threatening or serious bodily injury, enough to the point where, yes, my use of a gun, deadly force, was reasonable. So the court could find, yes, you're entitled to use some amount of force because you're being attacked, but could you have used a gun? Or did you have to use instead maybe your hands as well? So in that case that I had, my motion was actually denied because the court found that my client had used too much force. It wasn't reasonable. He could have used some type of force, but it was not reasonable. And you know, going back to what Senator Simmons had said, I mean, I think right now we've seen a rash of shootings nationwide, and I feel as a citizen even more strongly that I'm glad we have your stand your ground law here in Florida, because you know, it is pretty scary what you hear nowadays, and to be able to defend yourself for a law-abiding citizen is something very important.
Thank you. I want to follow up. We've got a few more minutes. There was a group that a senator from South Florida formed soon after the controversy broke in the spring, Senator Chris Smith from Fort Lauderdale, that recommended some changes in the law. And of course, the panel that Senator Simmons is sitting on now is reassessing the law and some other laws. If you were a member of that panel, do you think you would be seeking any adjustments in the law? Would you be arguing based on your experience of having argued for the law?
No, I don't think so, because what happens when a law is passed, then the courts get to interpret that law. And this stand your ground law has gone up to the Florida Supreme Court. And the Florida Supreme Court, in different cases, has put out the mechanism to be followed. They've already spelled it out. They've said, under this law, this is what needs to happen. You need to file a motion. This is the burden of proof on the defendant. If he's not successful, this is what you need to do next. So they've already spelled it out for us. So I don't think we really need to change it. I think that it works the way it is. I mean, that's my perception, that this Florida Supreme Court has already put it in, had to be done. There were some cases beforehand that the law was applied incorrectly. They felt that they were not giving defendants evidentiary hearings. The courts were just denying the motion, saying, hey, your motion doesn't sound like you should have done it, so we're just going to deny it. So that's all been corrected now with the opinion from the Florida Supreme Court, so I don't think we really need to change anything at this point.
I mentioned that some prosecutors were outspoken in opposing the law at the time that it was passed. As someone with some experience as a prosecutor yourself, can you see why this law might have been objectionable to prosecutors?
Well, I think law enforcement and prosecutors, they never want to see any citizen take the law in their own hands or be vigilantes. So that concerns any one of those fields. And they might have thought, well, that's a little scary to say you can use deadly force will give you immunity, and people rely on it. We actually represented someone in Seminole County that it was a road rage incident, and the other individual got out of his vehicle, came up to our client, reached in his car to strike him, and our client took his gun out and shot him. And we didn't kill him, and he was taken down to the police department in Seminole County, and he was let go, and he was found to be immune. And this was approximately 2 years ago, and never really made the media or anything, but you know, it's nice to know that you have the right to not have to sit there and take that in your vehicle and, you know, be scared or not be able to use and defend yourself. Under the old law, you would have to try to drive away or make some effort.
Okay, thank you. And now we're going to go for another perspective to Judge LeBlanc. Judge LeBlanc, you're recused on this one, but Attorney Umansky, do you have anything else to add?
Well, I don't think that part of the case is going to affect, if they file a sitting ground motion, the judge's decision, because just him getting in and out of the car, he could just be strolling up to an individual saying, hey, what are you doing here? It's what happened when the two of them met, got together, and how that altercation happened is what's going to determine the issue. Because this didn't happen at the vehicle. This happened after. So I don't think that's going to affect the judge's decision if they file a motion. Now, it may affect the jury. The juries don't like things like that. So the jury may say, whoa, why did you even get out of the car? So maybe that will go with their thinking, but I don't believe it'll affect the actual motion if it's filed.
I think Paul had a question in the back, and then we'll revisit.
My name is Joy Zuckin. I'm a civil defense attorney for Cole Scott Hussein. I have two questions. Number one, has the denial of immunity ever been appealed? And number two, has there ever been any type of follow-up with regards to exclusion of any testimony in the immunity hearings, for the evidentiary hearings, where the defendant has gone to trial?
Well, my review of the case law shows that an appellate court is not going to overturn the trial court's factual findings. Therefore, as long as there's competent evidence to support the trial court's decision, in the cases where there's been appellate rulings, it's basically the standard hasn't been applied correctly, or maybe the motion was just denied summarily without a hearing. There's been other issues, and so I think that you're not going to touch the trial court's decision to believe or disbelieve the witness and credibility issues. So that's not happening.
For immunity, then why would you say that I can't say anything because I might be prosecuted?
Well, it depends on the facts of the case too. If there was 10 witnesses to the incident, they can testify for you. The defendant may not have to take a stand at an immunity hearing, and they can just rely on their witnesses. However, a case similar to the Zimmerman case, well, the only person obviously that could testify is himself. So he would have to waive his Fifth Amendment right, and whatever he says could be used against him at a trial subsequently. There's no immunity from the testimony, basically.
So you're saying he's still subject to cross-exam,
Yes.
even in the immunity hearing,
Absolutely.
If he chooses to
if
testify.
he chooses to testify?
And I just want to comment one last thing on what Judge LeBlanc said. Because the statute's worded what the person reasonably believes, it doesn't matter what's actually true. So let's, for example, in the George Zimmerman case, if he felt he was going to die or felt like I'm losing consciousness, that's all that's important. Now, the medical evidence may show, but you know, you had a scratch. You know, so it's the way it's worded. You know, it could be they could argue at the hearing that he believed he was going to have some great bodily harm. This is what he believed, and now they can decide this is reasonable. Or the court could say, well, under this circumstances, yes, regardless of the medical evidence may have shown something different, which I don't know what that medical evidence is ultimately going to show.
What I think she said
And
is correct.
Mr. Simmons' defense says, look, Trayvon Martin initiated this. The law says, well, okay, let's say he did initiate it, but if he clearly indicated to you, I'm stopping, I'm not going to do anymore, then you have a duty to stop too. It says you can't then keep going at it and say, too bad. So that's going to be an interesting issue because the statute does address that situation as well, saying you can't rely on self-defense if the initial aggressor stopped and relayed that information to you.
And yet there's quite a furor over this piece of legislation since the Trayvon Martin case. Attorney Umansky, do you think this furor has more to do with the law or more to do with the circumstances of the case?
I think it has more to do with the circumstances of the case. As Judge LeBlanc said, these are real fact-intensive type of cases, and I think the way this Trayvon shooting occurred, what happened afterward, is more upsetting to people than the law itself. The law's been around. That's what I'm saying, since 2005. Everybody was okay with it. And then this happened. So I think, just like I said before, we shouldn't repeal a law based on maybe what we perceive as it being used maybe the wrong way, in a way that we prefer it not to be used in one case. A law is more than just one case, and I don't think it's right to repeal it based on one case, when it's worked in many other cases and had the right effect.
The expression.
And, Ms. Romo, if I could just comment on the statute as it's written, that you're immune from arrest and prosecution, and why is that important, and why I feel that it should stay that way, and we shouldn't change it. If we took out that language, then what does that mean for someone who's supposed to be immune? That means that, hey, we can still arrest you, create an arrest record. Let's say you're someone who's never been in trouble before, make you post a bond, get out of jail, and then find out, hey, you're immune. Well, you just maybe destroyed this person's career, their livelihood, and everything else that goes along with it. And now they've got to hire an attorney to try to expunge that arrest record. So to give really the law its full effect and what's intended, we have to keep it the way it's written. It must be immune from arrest and prosecution, not just prosecution. And it's similar to a statute of limitations defense. The way the law used to be interpreted as far as statute of limitations was, hey, if you want to file a motion saying that statute of limitations apply, you first had to get arrested and file that motion. And the courts held that, no, you don't. You don't have to get arrested. You can argue that, hey, my case is too old. There's an outstanding warrant for my arrest. I don't have to turn myself in first and then file the motion. I shouldn't even have to do that. And the courts held that's correct. And that's the way it should be. It should stay with stand your ground. It should be both immune from arrest and prosecution.
Well, I'd like to thank everybody for their kind attention and good questions today. I think we've reached the point in the program where I'm going to turn it back over to Beth.
Thank you so much, Paul Owens and the panel. How about a round of applause for our moderator as well as our Judge LeBlanc. Thank you so much, all of you. This has been spectacular. Thanks to all of your input. We worked so hard on this and we so appreciate all of your work. I want to be sure to remind you again to register online for our upcoming event, September 29th, to meet litigated and arbitrate. Also, be sure to get your CLE certificate before you leave. Michelle has all of those for you all. Thank you again to our sponsors, Digital Legal, also First Choice, who provided all the food, they videotaped. They're just incredible. Thank you so much for coming, everyone. We really appreciate it.